talking about the differences between inland and overseas spousal sponsorship. Within the family class category of immigration, there are different types of spousal sponsorships that one can pursue, such as spousal sponsorship, common law partner sponsorship, or conjugal sponsorship. Additionally, there are two different categories that you can apply for. Those are the inland spousal sponsorship or the overseas spousal sponsorship. In this video, I will address the different types of relationships, as well as the different categories that you can choose from when applying for a spousal sponsorship. As previously mentioned, the different types of spousal sponsorship are marriage, common law, as well as conjugal. When applying for a spousal sponsorship for a marriage, you must provide a marriage certificate, as well as any other evidence of a marriage ceremony or any photos or evidence that you can prove that you have in fact gotten married. In a common law relationship, you must prove that you have been living together for at least a minimum of 1 year in order to prove that you are in a common law union. It is extremely important to provide as much evidence that you have been living together and that you are in a common law relationship so that the immigration officer can see that the relationship is genuine. When sponsoring your conjugal partner, it is very important to prove that you have not been living together, however, that your relationship has been in effect for at least a minimum of 1 year. Additionally, you must prove that the relationship has been continuous. The difference between a common law partnership and a conjugal relationship is that the pair or the partners do not have to live together. The reasons for this can be for several different factors. For instance, you can have several different barriers that will prevent you from living together, such as immigration factors, sexual orientation, as well as cultural reasons. It is extremely important to prove to the immigration officer that these barriers are very real and significant to prove that you are in a conjugal relationship. For this specific spousal sponsorship application for a conjugal relationship, you can only apply for the overseas spousal application. You cannot apply for an inland spousal application. Now I will explain the difference between inland spousal sponsorship and overseas spousal sponsorship. The main difference between an inland spousal sponsorship and an overseas spousal sponsorship is where your spouse is currently living. In December of 2016, the Canadian government had actually announced that the processing times for inland spousal sponsorship and overseas spousal sponsorship are actually reduced to about 12 months, which is about 1 year. For an overseas spousal sponsorship application, your spouse must reside outside of Canada in order for you to apply for an overseas spousal application. The one disadvantage of the overseas spousal application is that it will be extremely difficult for you and your spouse to live together while they are applying for a spousal sponsorship. On the other hand, if your spouse would like to come to Canada while it is being processed, they can apply for a temporary resident visa, which can allow them to come to Canada temporarily. However, it is important to note that even with a temporary resident visa, there is no guarantee that the spousal application will be approved. However, all of the immigration matters are in the hands of the immigration officer, and they have the ultimate discretion whether or not your application is approved. In contrast, for an inland spousal sponsorship application, your spouse will actually be within Canada while you are applying. The one requirement for this specific application is that your spouse must have a valid authorization to stay in Canada or a temporary resident visa while applying in Canada. One of the major benefits of this spousal application is that your spouse can actually apply for an open spousal work permit while the application is being processed. With an open spousal work permit, your spouse is actually allowed to work anywhere in Canada for any Canadian employer. They can essentially work while the application is also being processed, which is very beneficial. Additionally, in December of 2014, there have actually been an announcement that the processing times for an open work permit for spouses are actually a lot faster. Overall, for any spousal application, it is very important for you to prove the genuineness of your relationship and prove to the immigration officer that your relationship is in fact real and very genuine. Therefore, as much evidence that you can provide for the immigration officer will be extremely beneficial for the strength of your application. Evidence that you can provide are things such as joint documents, so this would be government information, documents, joint bills, any property documents that you have in both of your names, etc. Anything like that will definitely help in proving that your relationship is real. If you have a spouse that you would like to sponsor, we can definitely help you with the process here at Akrami and Associates. We have helped many of our clients be reunited with their spouses here in Canada, and we can definitely help you out with the application process. With Akrami and Associates, there's always a way.